Welcome to this year's cycle of lectures, Daily Life and Norms in Rome, a cycle of lectures organized by the Séneca Institute and coordinated by our director, Professor Consuelo Carrasco, who is today with us. It is my great pleasure to introduce today's guest speaker, Professor Albert Gómez Jordán. Professor Gómez holds a PhD in Roman law from the Rovira Virgili University of Tarragona, where he currently lectures on Roman law, comparative law, and Romanistic foundations of European private law. His research focuses on Roman civil procedure, judicial stipulations, contractual law, succession law, and the evolution of the contract of sale in modern contexts, including highly relevant and interesting topics such as cryptocurrencies and digital assets, areas in which he has published extensively. Beyond academia, Professor Gómez is also an experienced civil litigation lawyer. Today, he will share his expertise on Roman civil procedure, exploring who served as private judges in ancient Rome, their functions, and much more. Professor Gómez, the floor is yours.
Thank you very much, Professor Carreño. Well, first of all, I would like to thank you all to be here. And I would also like to thank Professor Consuelo Carrasco and Professor Rosa Maria Carreño for the invitation to this prestigious university, but also this prestigious cycle of online conferences. For me, it's an honor to be able to speak here today, especially on a subject that I am passionate about, the Roman civil procedure. Well, my lecture is entitled Exploring the Officium Iudicis, Judicial Duties and Legal Knowledge in Roman Law. My intervention aims to show which were the function and duties of judges in classical Roman law and whether or not judges were required to have legal knowledge. Well, from today's from today's point of view, not legal, from today's point of view, it's strange to ask whether a judge should know the law or not. Because if there is one thing that characterizes a judge today, it's his or her profound knowledge of legal rules. However, if we go back to ancient Rome in classical times, the position is less clear. Well, the figure of the judge and his role in the Roman civil procedures in which disputes were resolved between private individuals underwent an evolution from archaic law to Justinian law, that is, from the procedure of the actions of the law, in Latin legis actiones, typical of the archaic period, passing through the formulary procedure of the classical period, and reaching the post-classical procedure of the cognitio extraordinem, also in force in Justinian period, the last period of Roman law. Well, the legis actiones procedure was characterized by its orality, formalism, and ritualism. Reliance was placed on the magical power of words. Moreover, there were only 5 legis actiones through which claims could be submitted. This procedure was exclusive to Roman citizens. The formulary procedure, typical of the classical period, arose to settle disputes between citizens and peregrini, that is, foreigners. Although later, from the Ebusian law onwards, it was also available for disputes between Roman citizens. This procedure included writing through the formula, which was a written document drawn up by the praetor in agreement with the parties, which served as a guide for the private judge. The judge was a Roman citizen chosen by the parties to decide the dispute. The actions that could be brought were set out in the praetor's edict, and there was a distinction between actions in rem, which protected rights over things, and actions in personam, which served to claim amounts or restitution arising, for example, from contracts. In this procedure, the formulary procedure, the judgment issued by the judge could not be appealed. The last one of the procedures, the cognitio extra ordinem procedure, typical of the post-classical and Justinian era, was an entirely written procedure that took place before a predetermined official judge, which formed part of the bureaucratic organization of the empire. In this procedure, the sentence could be appealed to the emperor. Well, the sources show unequivocally that the post-classical judge was a public officer who was in charge of the procedure from the formal notice to the judgment, and was therefore required to have a deep knowledge of the law. However, this cannot be said about the classical judge of the formulary procedure, that one of the classical Roman law. Well, it's now time to focus on the formulary procedure typical of the classical period. This procedure, as was the case in the legis actiones procedure, was structured in two phases: the in jure phase, the first phase, and the apud judicem phase, the second phase. While the in jure phase was directed by the magistrate, the praetor, and had the essential purpose of establishing the legal controversy through the drafting of the written formula, which was this guide of the judge to decide the controversy, the apud judicem phase, the second phase, was presided over by the iudex privatus, and had as its objective the taking of evidence through the trial and the resolution of the dispute by means of a judgment. All of this always took place within the framework of the formula, which, as we have pointed out, served as a guide to the judge, or for the judge. Well, my intervention will focus on the study of the figure of the iudex privatus, his duties and functions, and his relationship with the law in the classical period of Roman law, therefore in the field of the formulary procedure. We must start from the basis of a dismal reality. Few sources have come down to us in the classical judge, on the classical judge and his role in the apud judicem phase of the formulary procedure, since we are dealing with a phase, the apud judicem, which, due to its characteristics, attracted little attention from jurists. In fact, the apud judicem phase focused on the taking of evidence proposed by the parties, by the plaintiff, by the defendant, and ended with the giving of the judgment by the judge. The practice of the evidence focused on the facts, not on the law, was the domain of the rhetors and orators, and this seems to be demonstrated in a fragment of the Roman jurist Ulpianus, contained in Digest 5179-1. This text indicates that governors, who often respond to judges who are in doubt about the applicable law, should not advise those who consult them on the facts, as they understand that this discredits them and gives rise to favor and intrigue. Well, we must bear in mind that in the Justinian legal sources, more specifically the Digest, the references to the figure of the iudex in classical jurisprudence were significantly modified or adapted by the compilers to the procedure of cognitio extra ordinem that was in force in the 6th century after Christ. Consequently, this has historically produced an added difficulty in interpreting the fragments referring to the iudex, taking into account the deep difference between the classical iudex privatus and the iudex officer of the cognitio extra ordinem. This has led the doctrine to have to resort inevitably to literary sources, with the intrinsic doubt about their reliability, and epigraphic sources in order to obtain as much information as possible about the role and development of the figure of the classical iudex in this second phase, the apud iudicem phase. Well, the aim of my intervention is to determine, on the basis of legal and literary sources, whether or not there was a legal obligation of the iudex privatus to have a certain technical legal knowledge of the law in order to be appointed and decide in a civil case. That is, if he had to be juris periti, it's the technical word in Latin, that is, knowledgeable in the law, or whether he could perform his function without being required to have such knowledge, and therefore whether he could even be a layman in law, juris imperiti. Well, in order to try to shed some light in this question, it's not easy, we will deal with some aspects that may determine an opinion on the issue. First of all, the election of the private judges in the formulary procedure, that is, the electio, the judicial function of judicatio, the oaths that judges had to and could take in the framework of the formulary procedure, the content of the officium Iudicis, an examination of the typology of the judges as shown in the literary sources, an analysis of the figure of the consilium, and a reflection on the requirements and effects of his sententia, that is, the judgment. Well, first of all, we have to face the electio. Okay, the choice of judge in the formulary procedure was made at the in jure phase, before the praetor, this magistrate, Roman magistrate, once there was agreement on the specific clauses to be contained in the formula. For example, the intentio, that is the plaintiff's claim or pretension, and the possible exception of the defendant, among other clauses. And before the procedural moment of the litis contestatio, that is the stage of securing the dispute before witnesses with the important effects that this entailed. The parties could agree on the appointment of a suitable person as a judge, who could be chosen from the album judicium, that is the official list of judges that exists, or they could choose someone who was not on the list. In either case, if there was agreement between the parties, the praetor inserted the name of the iudex in the formula. On the other hand, if there was no agreement, the judge was chosen by lot, taking into account the persons listed in this album judicium. The inclusion of the name of the judge was made at the beginning of the formula. Titius, iudex esto. Titius, be judge. Why? Because it was the formula, an instruction directly addressed to the judge. Here, on the screen, we have an example of the formula of an action of intimation for a specified sum of money. It's called this action condictio in Latin, or actio certae creditae pecuniae. As we can see, the first part, the designation is the designation or the appointment of the judge. Titius, be judge. Okay, because it's an instruction to the judge. The second part in blue is the intentio, that is the plaintiff's pretension. Okay, and for example, here it is, if it's proved that numerius negidius, this is the Latin name to identify the defendant, ous aulos agerios, the plaintiff, 10,000 sesterces, matter of the dispute, this is the intentio, then, if that is proved, not, let Judge Titius condemn Numerius Negidius against Aulus Agerius for 10,000 sesterces. If not, if it is not proved, acquit him. Okay, that's the written formula that the judge received and read. Well, you can also see on the screen an image, a tabula cerata, a wax tablet, which was the medium of which the formula was usually written. This formula was written by the praetor, the magistrate, in agreement with the parties, and then handed to the judge in order to open the second case, the apud judicem case. Well, regarding the profile of the judges contained in the official list of judges, it should be noted that in order to be registered in the album judicium, in this official list, in addition to social and political conditions required in different historical periods, the judges had to be Roman citizens, male, not be subject to a cause of mental incapacity, have reached a certain age. In some periods, 30 years, in others, 25, 24. Reside in Italy, although this rule was attenuated over time, and not be endowed with an imperium, power equal to or greater than that of the magistrate, than that of the praetor who had authorized the judicium in the injuria phase. Okay, these were the requirements. In the handout, you will identify three texts that reflects some of these requirements. Digest 5.1.12.2, Digest 4.8.41, sorry, and Digest 42.1.57. Sorry, because we do not have time to examine deeply these texts. Well, in this sense, the freedom of choice of the private judges was part of the legal security in the Roman procedural system, precisely because the two parties agreed to appoint a person who, in advance, they both believed would judge in favor of their interests, and thus bound themselves to the decision of a person they themselves have chosen. The sources indicate that the essential duty of the Iudex Privatus, once appointed, was to give judgment. Unless, as we will examine later, he swore that he did not see the matter clearly. This essential duty is set out in the following fragments of the digest. Digest 5.1.74 Principium and Digest 42.1.55. The first text says, a judge can be compelled to render a decision with reference to any matter of which he has taken cognizance. And Digest 42.1.55 says, after a judge has once rendered his decision, he ceases to be judge so far as this case is concerned. It's our practice that a magistrate who has once rendered judgment for a larger or smaller sum than was claimed cannot amend it, because he has performed the duty of his office, well or ill, once for all. Likewise, the jurist Gaius, classical jurist in Gaius Institutes 443, points out that by means of the condemnatio of the formula, that is the last part of the formula, condemn or acquit, the judge was given this possibility, condemning or acquitting, and that was his main task within the formulary procedure. It's clear condemnatio est ea pars formulae que judici condemnandi absolvendive potestas permittitur. Condemnatio is that part of the formula by which authority is granted to the judge to condemn or discharge the defendant. Well, this function, to give a judgment, is called judicatio. Jus dicare, to say the law, to say the law, which is the authoritative function entrusted to judges and which consists of deciding on a specific legal disputes, especially by means of judgments. Being one of the duties, in Latin it's called munus personale, of the Roman citizen when elected and appointed as iudex, and which is based on a duty of solidarity of man towards his own fellow citizens. It's incumbent on the iudex privatus to duly fulfill this public law obligation. It's not only a munus personale, it's a munus publicum. And in case of failure to do so, he is subject to liability. Digest 5:178 is clear. Quipe judicare munus publicum est. To act as a judge is a public duty. Well, by contrast with the praetor, the magistrate that has had imperium and also jurisdictio, the classical iudex lacks these two powers, since his function is not to administer justice, that is, to prepare the dispute, to fix the position of the parties, but to give a judgment, to resolve the civil legal conflict that is brought to him in the formula by means of a condemnatory or acquittal decision. Jurisdictio and judicatio, these two functions, are analogous activities, in fact, but with different starting points, because the magistrate, the praetor, declares as the holder of potestas, and the judge, although subject to the limits established by the praetor in the formula, declares his opinion as the revealer of a specific prudential knowledge, the auctoritas. In this sense, a judge's opinion on the dispute was the quintessential act of judicatio and formed part of the procedural acts that we call authoritative, as they were proper to the understanding, that is, the knowledge, not the will, the power. This is the praetor. Well, in order to carry out his judicial function in accordance with the officium iudices and always with the aim and purpose of fulfilling the judicatio, the judge had to ensure his performance in the apud judicem phase by means of oaths. One of these oaths was the cum veritate et legum observatione judicium oath, an imperial constitution emitted by the Emperor Justinian I in 530 after Christ and addressed to the prefect of the Praetorium is the main legal source that has come down to us to the present day concerning the oath that the classical judge had to take at the beginning of his duties. This imperial constitution is found in Codex, the Codex of Justinian, 3.1.14 Principium. This Justinian constitution, you have the translation in the handout, begins with a warning that the constitution will deal with something which is neither new nor unusual, but admitted by the ancient legislators, but which, having been neglected or disregarded, or perhaps falling into disuse, causes no slight prejudice in cases. The text then makes an explicit reference to the ancient obligation of judges to swear an oath. the fragment points out that the ancient judges did not pass final judgment unless they had first taken an oath that they would proceed in the trial entirely in accordance with the truth, and observance of the law. Cum veritate et legum observatione. Well, many authors have given validity to the content of this oath in the context of the classical period. In our opinion, what is clear is that an oath in which general recourse is made to the truth and the law in judicial proceedings without a determination of these concepts, general concepts, has more to do with the post-classical procedure of cognition extra ordinem than with the formulary procedure. The content of the oath that is contained in this constitution reminds us to the inquisitorial principle, which allowed the judge to make enquiries into facts that the parties had not alleged or even to propose new evidence, and the principle of legal or assets evidence, which advocates that the value that the judge has to give to each of the means of proof is established in a legal scale that fully binds him. But these both principles are not from the classical period, are not from the formulary procedure, are principles of the cognitio extra ordinem, the post-classical period. Then the oath does not fit in the, for example, dispositive principle and the principle of unfettered evaluation of the evidence that prevailed in the apud judicem phase of the formulary procedure in the classical period, which only allowed these two principles the judge to examine the evidence proposed by the parties and through his free assessment form an opinion which led to the judgment. For these reasons, we consider that the expression cum veritate et legum observatione is more easily adapted to the characteristics of the cognitio extra ordinem in force in the Justinian period. Another oath, a second oath that we consider should be examined is the sibi non liquere oath. It's a more well-known oath, which could be taken by the iudex once the evidence had been taken and whenever he did not see the matter clearly at the time of giving judgment. I don't see the matter clearly. The only two sources that have come down to us regarding this oath are one of a legal nature, this one, Digest 42, 136 of the Juris Paulus, and other of a literary nature, that is Aulus Gellius in Notes Acticae 14-25. In the event that the judge pronounced the oath, the parties would have appointed a new judge, without the need to go through the litis contestatio again, that is, without the need to write a new formula and present it to new witnesses or the same witnesses. As is clear from Ulpianus 13 Ate Dictum, Digest 4.8.13.4. Then, when the judge had not reached a certain opinion on the matter in dispute, he could exempt himself from giving a judgment by swearing precisely that he did not see it clearly. He was thereby relieved of the office of judge, and another judge was appointed. It's clear, therefore, that the fact that the classical judge could resign from giving judgment in the case in which he had been appointed, because it was not clear to his conscience, implies that he could have withdrawn either for factual questions related to the evidential activity or for reasons of ignorance of the law. For example, because he didn't know how to interpret a formulary clause correctly, and could not turn to any jurist for its interpretation, or even for personal appreciations in relation to the dispute, among many other reasons. The way to fulfill the judicatio, this duty, is through the officium judicis, an expression used by the Roman jurists when describing the scope of the power of the judges. In effect, the officium, or the moral duty, indicates what a judge must do, and that officium is subject to ascertaining the use and the factum in terms of the formula, taking into account the impossibilities and difficulties of the parties in the process. The Romanistic doctrine do not have a single opinion regarding the meaning and the content of this officium judicis in the classical period, among other reasons because we know that the books of the jurists who dealt with this question, the officium judicis, were lost in post-classical times, even though their existence cannot be doubted since they are documented. For example, here we have a literary fragment, again of Noctes Atticae of Aulus Gellius, that indicates that the jurist Quintus Aelius Tuberonis wrote a treaty or a treatise on the officium judicis, which has not survived to the present day. Various authors have considered the officium judicis a discretionary power based on aequitas, the equity, but not strictly in the common law sense, it's in the Roman law sense, which gave the judge a function of creative justice, allowing him, for example, to facilitate the acquittal of the defendant in judgment if he promised a judicial stipulation, that is, a promise before the judge. Well, in our opinion, the aequitas, this equity in the formulary procedure, must be substantially predicated on the magistrate, the praetor, in the injury phase, and in particular at the moment when he draws up the formula, in order to preserve equality of procedural arms for the parties, plaintiff and defendant. This equality of arms would essentially take the form of the intentio of the plaintiff, the pretension, and the possible acceptio of the defendant, as well as through the other formulary provisions. Well, we consider that the content of the officium judicis was different in each of the civil trials, and consequently it's not difficult to think that certain judges, regardless of whether or not they were laymen in law, would have needed, surely or not, external help in interpreting the formulary clauses. This is the case now. First of all, the profile of the private judgment. Well, we have to analyze what typology of judges existed in the period when the formulary procedure was in force. In the literary sources, the two opposing models of the figure of the judge have been revealed. There are texts in which the judge is presented as a personality who deserved the greatest trust and respect, and who was morally decent and blameless. And on the other hand, there are specific references to judges who did not take morals very seriously, and who often led a relaxed lifestyle, and whose conduct was not always irreproachable. Which of these two types of judge was usual in ancient Rome in the formulary procedure? Well, the figure of the usual judge was not a synthesis of these two extremes. Roman judges, must have been heterogeneous and could belong to any social class, and could be rich or poor, educated or uneducated, urban, rustic. As for the legal training of the judges, or rather their lack of legal knowledge, the lack of legal expertise of some judges, without diminishing the importance of the figure of the judge, was perfectly conceivable in the classical period, since there are sources that rely on judges who lacked any expertise. They were juris imperiti. A passage from Quintilianus of the Instituto Oratoria demonstrates this. Maybe we could read it because it's, I don't know if I have. Yeah. The text says, but neither of these is disgraceful when it's done for a good reason. Therefore, it's not a vice either. To tell a lie is something occasionally allowed even to the wise man. And as for rousing emotions, the orator is bound to do this if the judge cannot be brought to give a fair judgment by other means. Judges can be inexperienced, people who frequently need to be decided, to save them from being wrong. If we had wise men as judges, and assemblies and councils of all kinds were made up of the wise, if hatred, influence, prejudice, and false witness had no power, then the scope for eloquence would be very small, confined more or less to giving pleasure. But as the feelings of audiences are fickle, and the truth is exposed to so many evils, we must fight with the weapons of art, and employ whatever means serve our purpose. A man who has been driven off the right road can only be brought back to it by changing course again. In this passage, Quintilianus advises his students to adapt their discourse in difficulty and argumentation to the receptiveness of the listener. In this case, to a judge who is completely lacking in legal experience and competence, and who therefore will not be at all in a position to understand the meaning of an intricate discourse with a high jurisprudential content. This text clearly indicates that people who were ignorant of the law and inexperienced could judge, which in our opinion demonstrate that this type of judge would also exist in judicial practice. Well, what practically all the Romanistic doctrine does agree is in the fact that the Iudex Privatus, whether or not he knew the law, could have been advised from a technical legal point of view in the apud judicem phase, the second phase of the formulary procedure, by a concilium of experts, or have listened to the opinion of jurists. Opinions that were in no case binding for the judge. There are only opinions. It should be noted at this point that the praetor in the injure phase was often assisted by a concilium of jurists who contributed their expertise and which, like the concilium of the Iudex, was not binding either. Well, the concilium was mainly made up of jurists, although some authors also state that its members could include, for example, friends of the judge, or renowned jurists. There are several literary sources that prove the existence of this concilium. We have no time to examine these sources, only I appoint them. For example, Valerius Maximus talks about this concilium, Cicero, Suetonius, and Gellius. It seems clear that the judges would only have turned to the concilium in cases that presented a legal difficulty that made recourse to this entity created specifically for the concrete legal civil controversy. Well, the last point, the sententia, the judgment. The judgment of the formulary procedure is the final decision of the civil proceedings, handed down by the judge after the evidence have been examined. In the sources, we also find the mention judicatum, which would correspond to the opinion that the judex had on the matter in dispute. Although other authors believe that this latter expression would rather refer to the condemnatory judgment. Judicatum could be this condemnatory judgment, by which the defendant is ordered to pay a specific amount to the plaintiff. Well, as we have noted before, the Juris Gaius indicates that the judgment was governed by the binomial condemnare absorbere, condemnating, acquitting. Likewise, in the case of condemnation, the judgment had to be in money. The condemnation had to be in money, precisely because the condemnatio of the formula had to be pecuniary. The judge had to give an impartial judgment. Otherwise, if he gave an unjust judgment, he was subject to liability, is that we know as judex qui litem suam fecit. Moreover, the judgment was not subject to any formality. It did, however, have two important effects. An enforcement effect, which gave rise to the obligation to comply with the judgment or to submit to the actio judicati or other enforcement mechanisms, and a second effect that is called res judicata, which meant that it was not possible to raise the same question or matter again between the same parties. It was not a legal requirement in classical times that the judgment of the formulary procedure had to be reasoned, and consequently, it was not a legal requirement of the judgment that the judge had to justify from a legal technical point of view, on the basis of the evidence, the reason for the condemnation or for the acquittal. Another interesting debate is whether or not the judges in the formulary procedure were bound by previous judgments. Well, this legal perspective has been dealt with essentially the doctrine coming from the common law, obviously, precisely because of the influence of the doctrine of the precedent in their legal procedural system. A sector of the doctrine has considered that judges would have contributed to the development of the law through their judgments, and their opinions range from the observation of a certain judicial practice in which there was a reference to previous decisions, to the assertion of the existence of a generalized link to previous decisions based on the fact that judges had to deal with the questions of law and were people with legal knowledge. They were not laymen, although no solid sources are provided to support this trend. We agree with many authors that it makes no sense to identify a theory of precedent in the sphere of the Roman formulary procedure, and much less of the existence of a case law of judicial rulings. In our opinion, the judicial designation in classical times was for a concrete case in which a specific evidence provided by the parties, by the plaintiff, by the defendant, in relation to that controversy, were examined by the judge. And it was the judge himself who had to form a legal opinion, without influence or interference from other matters and other evidence unrelated to the case being judged, in order to be able to give his definitive sentence, his definitive judgment. Well, what has been said up to now leads us to affirm the main conclusion of my intervention. According to the legal and literary sources, it was not a necessary requirement in classical times to have a technical legal knowledge of the use of the law in order to be elected iudex in the formulary proceeding, in order to be elected judge. Basically, since the judgment did not have to be based on legal grounds. Well, thank you very much for your attention.